This is John Lande, retired professor at the University of Missouri School of Law Center for the Study of Dispute Resolution. This is the last of 4 lectures talking about how lawyers can help clients make litigation decisions. The first lecture talked most generally about how lawyers can work well with clients and counterpart lawyers. The second lecture talked about using the litigation interest and risk assessment, or LIRA, approach in working with clients to help them understand the situation and to develop a strategy. The third lecture talked about using the LIRA approach in working with counterpart lawyers and the other side in negotiating resolutions that hopefully will satisfy your client's interests. And this last lecture is pulling it all together to help clients make decisions about litigation and negotiation. As I've said, these lectures are based on my understanding of experiences in the United States. There are variations between and within countries. Some of the things that I will describe are applicable in virtually every country, and others in some places and not others. And even within individual countries, there are variations. You will get a copy of this PowerPoint with links with more information, and you can recognize the links because they are in blue and are underlined. So what this lecture is going to talk about is why concepts are important. And the reason is that they help people understand the world, and they help people communicate with each other. They help people plan, perform, and analyze actions. And they help people build theories about how things work and what interventions might have particular effects. And in particular, useful concepts can help lawyers help parties. And that's really what this entire series of lectures has been about, is to provide you a series of concepts that will help you think about how you can do these things, how you can understand legal problems, how you can communicate with clients and with your counterparts on the other side, how you can plan and perform, analyze actions in your legal practice, and how you can use theories to do all this. And a lot of this, or some of this, is going to summarize or build on the earlier lectures. So for example, here we're talking about negotiation texts that talk about confused models of negotiation and even the definition of negotiation. And here's a link that provides more detail about that. There was a symposium at the University of Missouri, which we were called the Tower of Babel Symposium, that describes in more detail of the confusion about negotiation models. And then the American Bar Association Mediation Research Task Force did a report demonstrating that there are confusion about mediation models, the concepts used to think about and talk about mediation. As you may know, mediation is a process involving a neutral third party to try and help people reach agreement. Essentially, it's like negotiation, except with this neutral mediator who's going to help the parties and lawyers try and reach an agreement. Now, the negotiation models that we've talked about are these 2 models, and they have various names. We've used distributive, competitive, adversarial, positional, or I've talked about this as a counteroffer process. So that's one of the models that you'll see described in negotiation texts. The other one is called integrative, problem-solving, cooperative, interest-based, or what I've referred to as the interest and option approach. And they completely overlook what I've described as the ordinary legal negotiation approach. And rather than focusing on the models, I've suggested focusing on variables. And the reason for that is that lawyers use different models for different issues and at different times. So the models are confusing. They don't help. They provide concepts that don't help you as lawyers make the kinds of decisions that you need to make. And so instead of focusing on the models, I suggest that you focus on the component variables, such as in the adversarial model, the assumption that the goal is to maximize the results of each negotiator, that there are zero-sum assumptions, that one person's gain necessarily is the other person's loss, that you're going to treat the other side as a hostile opponent, that you're going to use a counteroffer process, and you're going to focus on the Batten outcome, the expected court outcome, as the basis for negotiation. And you're going to use hard bargaining tactics, time pressure, threats, misrepresentation, all sorts of things to try and intimidate the other side to give you a more favorable result. As I've described, some of these variables and actions go together in a particular negotiation. Often they don't. I did a study of lawyers' negotiations, and I asked them to tell me about the negotiations from the beginning of the case. And I found out that a lot of times lawyers use this counteroffer process of exchanging extreme offers, but they treat each other as respected counterparts, and they aren't using hostile, they aren't acting in hostile ways, and they don't necessarily use hard bargaining tactics. So rather than focusing on the models, you should be looking at the variables. And for mediation, there are also confusing models. And we haven't talked much about mediation, and I'm not going to go into a lot of detail, but the models are helpful in thinking about some of the activities that lawyers as well as mediators do. And the mediation theory talks about the most common models are the facilitative and evaluative models, which grow out of an article by Leonard Riskin. And his original concept combined very different variables, much in the same way that I've described that the negotiation models combine different variables. So there's another ABA task force that surveyed mediators and found very different views about what actions were helpful in most cases. And if you look at the range of these actions, they were all combined as evaluative in the original Leonard Riskin article, but mediators think about them, and in fact, these are very different activities. So giving a case analysis, including the strengths and weaknesses of a case, 2/3 of the mediators thought that that would be helpful in most cases, but only 38% thought that it would be appropriate for mediators to recommend a specific settlement, 36% to make a prediction about likely court results, and only 30% about applying some pressure to accept a specific solution. All of these activities are part of the evaluative model in Riskin's original concept, and yet they're very different actions, and mediators have different reactions to them. And I highlight that this was Riskin's original concept. He later modified it and said that this wasn't that helpful. Unfortunately, people still use the facilitative and evaluative models a lot. So what should you do with these models? Well, I think you should throw them in the trash. And as I've described, I think you should be focusing more on specific variables and focusing on party decision-making, which is most important. So the lawyer's main role is to help parties make decisions. And even in arbitration and litigation cases where adjudicators make final decisions, parties make decisions along the way, including whether to settle or not. So parties have to make decisions throughout a case, and it's your job as a lawyer to help them make decisions. You may be familiar with arbitration, which is a process in which a private third party makes a binding decision. It's similar to court, where the judge makes the decision, but in arbitration, it's not a court that does it, it's a private individual who has been agreed to by the parties. Now, there are a range of decisions that parties make about disputes, and lawyers can help parties make decisions to choose a process. So they may choose to negotiate, mediate, arbitrate, to litigate, or to go to trial. And notice that I have litigation and trial as two different processes. Parties litigate from the very time that one side files a lawsuit. Many cases settle after a period of litigation without going to trial. So litigation is this process that starts with filing of a lawsuit. Trial only occurs after a period of pretrial litigation. So lawyers help the clients choose a process and perhaps several different processes in a given case. They also choose how to design the process by making a variety of procedural agreements about how to negotiate or how to mediate or how to arbitrate. And then lawyers also help clients make decisions in a case about what to do in terms of what kinds of issues to raise, what remedies to demand in making negotiation strategy, what demands to make, what offers to accept. So those are the specific issues. So there are a lot of decisions that parties need to make, and lawyers are there to help parties make a full range of decisions. Now, of course, parties don't make all of these decisions. A lot of times they delegate those decisions to lawyers, but many times lawyers do consult with clients about them, and ethical rules may require lawyers to consult with clients about some of these issues. We've talked about this LIRA framework, which provides the three-part structure, focusing on the expected value of options, the tangible costs, and the intangible costs and interests. And again, we're talking about the future tangible costs and the future intangible costs, because the past costs are sunk costs and you can't do anything about them. And based on this, lawyers can develop litigation, negotiation, and mediation strategies using all of these factors. So this is the first of several slides putting this all together. So as I've just discussed, there are this range of types of dispute resolution processes, such as negotiation, mediation, arbitration, or trial, the procedures in the process, procedures for information sharing, logistics, time and place of negotiation or mediation, the timing, who will attend, all sorts of procedures about the process, and then the resolution of the particular issues that the parties are concerned about, that the legal matter is concerned about. And then the next set of issues are the issues in resolving the issues, the factors to consider in resolving these issues. And these are the LIRA factors, the value of the options, which in litigation are the expected court outcome, or in transactional negotiations, that's the profit from the deals, and the tangible costs, the legal fees and expenses, and then the intangible costs and interest, the stress, relationships, reputation, loss of opportunities, and many, many other things that are of interest to clients. And then there are these types of cognitions, things that the parties and the lawyers are thinking about, and actions. So it's helpful to think about the goals. Are the parties trying to get some partisan advantage to try and get more than the other side? Are they trying to get a joint gain, mutual benefit? Are they trying to reach some fairness, fair outcome? What is it that the client's goals are and the other side's goals are? And what are the assumptions? Are the assumptions that it's zero sum, that one side's gain necessarily means the other side's loss? Is it a positive sum where one assumes that it's possible to reach an outcome that makes both parties better, or even a negative sum where both parties are going to lose? And then the question is how you're going to allocate the losses. Then another variable is the attitude towards the counterpart. It's going to be hostile, polite, friendly. This is a very important variable that people often don't talk about, but it affects the dynamics and the way the process will unfold. And then what are the relevant norms? Is it the law, parties' interests, typical practice, going rates? What are the standards that people are going to be using in making their assessments and their arguments and their taking their actions? And then the communication process. Is it going to be a counteroffer process, an interest and option process of identifying the party's interests and options and then picking one, or a norm-based process? And then are the tactics? There are a whole range of different tactics. Are they going to use dirty tricks, like trying to intimidate the other side, or put time pressure to misrepresent? All sorts of dirty tricks, things that are going to, what are, I should put dirty tricks in quotation marks, because that's what they're commonly called. Or are the tactics going to be information sharing, or lots of other things? So that's a set of kinds of actions that lawyers and parties may take. And then what sorts of things might you as a lawyer do in relation to clients? Listening is the first and most important one that I will emphasize and re-emphasize. The timing of the listening, which should be from the outset and throughout, and the amount and the quality of attention and understanding that lawyers provide to clients. As I described in the outset, clients are often very frustrated because they feel that the lawyers aren't listening to them and aren't respecting them and aren't empathizing. So that's one type of action that lawyers take in relation to clients. And then helping the parties make their own assessments, and the timing and assessment, the timing and the amount and the quality of help in helping the clients understand and make their own judgments. Some lawyers do this a lot, and some lawyers don't do it very much, if at all, and just assume that the lawyers are going to be making the decisions without really engaging the clients very much. Of course, the lawyers themselves do some assessment of the options in terms of the timing and the amount and the quality and the confidence of the assessments that they provide to the clients. They'll also predict outcomes, what is likely to happen if they go to trial or if they consummate a transaction. And so again, the variables relate to the timing, quality, and confidence of the prediction. Lawyers will give advice, and sometimes they'll apply pressure. They don't always do that, but sometimes they do. And if so, the timing, appropriateness, intensity, and effect of pressure. Now, sometimes people think of pressure as a purely negative thing, and sometimes pressure is inappropriate. But sometimes lawyers provide helpful pressure that clients appreciate. Sometimes clients are indecisive. They have a hard time making decisions. And so lawyers may urge them to make decisions, to put some time constraints on. Lawyers may apply pressure if clients are doing things or want to do things that violate the law or that are unethical. So lawyers do a range of things in relation to clients, from listening to helping the clients make their own assessments, to giving the lawyers assessments, predicting outcomes, and giving advice, and sometimes applying pressure, and hopefully appropriately so. And these concepts are much better than models to help the parties because the models are too simple to express the complexity of disputes and the lawyer's actions. And the specific concepts help lawyers to understand situations, communicate with clients, recommend and implement litigation and negotiation strategies. And so to sum it all up, lawyers provide valuable services to clients by helping them make decisions about handling their disputes. It's a difficult process because legal disputes are complex. Expected court outcomes are uncertain. Tangible and intangible costs are major factors. And specifically about the intangible costs, they're often ignored, and they're subjective. Different clients have different interests, and they are concerned about different intangible factors, and they value them differently. And these are important issues that lawyers need to discuss with clients, and it's hard. And lawyers and parties have biases leading to bad decisions. These motivational cognitive biases that often lead to overconfidence and misjudgments, and leading to decisions to go to trial when it would be better to accept the other side's settlement offer. So using clear, specific concepts and techniques can help lawyers help clients. And this lecture series has been about providing you a set of concepts and techniques that you can use to help your clients when you're out in practice. And with that, we are done. So I hope you have found this valuable.